Dr. Solaiman has been working in this area for a number of years and has been advising the Ministry of Public Health on specific issues and the like. He is also, in addition to teaching the healthcare law course, he co-directs the healthcare and law series at Cornell Medical School here in Qatar. And so he's going to be providing a general overview and some of the legal issues that he's been focused on and the like. And then we're going to hear from Mr. Mohammed Hashim. And Mohammed is a lawyer here in the Sulaiti Law Firm. He heads the contracts department. As I mentioned earlier, he has spoken at our law school before. He originally hails from Egypt, but he has an extensive background in litigation. So I believe it's going to be this litigation experience. We're going to hear some nuances and ways in which specific issues have arisen in the context of practice here in Qatar. And so, Dr. Solaiman, I look forward to your remarks. And as I mentioned to my colleagues here, when they are speaking, I will go off. I will be here, of course, to stop the video on my end, put it on mute so we preserve bandwidth. And I know Dr. Solaiman also has a presentation he'll be putting up. So we look forward, Dr. Solaiman, to your remarks. And then after that, we will also then hear from Mr. Hashim. So Dr. Solaiman, the floor is yours.
Thank you so much. First, can I ask, can you hear me clearly?
I can hear you just fine. Yep.
Fine. Okay. Because speaking of bandwidth, just had some internet issues. So thank you for the kind introduction, Susan. And I second everything you said about our collaboration with Sulaiti. It's an important collaboration, and it's not just healthcare law topics. We cover many others. But I'll dive right in and share my presentation. So to take a step back, I think it's first important when talking about law to address first the reason for the law. So it's easy for us as lawyers to come in and say this is law X and Y and what it does, but that doesn't really serve a purpose on its own. I think what's important is that we discuss what the law is trying to do. Is it trying to bring about justice? Are we trying to compensate somebody for a wrong? And these questions are particularly important in the healthcare context because it's such a human topic. It's a human subject when a person in a hospital has received the wrong injection and they have died, when somebody has been admitted to a mental health institution and they're being assessed and you have to involve their family and there might be social stigma issues involved. When somebody might be accused of some sort of wrongdoing and there are there's sort of no way out for some people. They're sort of entrapped in these difficult human dilemmas that you can find in the healthcare context. So a big question is, what is the purpose of medical law and what's it trying to achieve? And this feeds into the medical law system in Qatar. So beginning with the concept of accountability, we could simply argue that, okay, let's take a scenario where a doctor has injected a patient into their with the wrong medication and they've injected it into their spine and the patient dies. So these are cases that have happened, not necessarily in Qatar, but in my general readings in medical law. So let's say that you then investigate and you find the doctor who did it and you hold them responsible. You say, well, Dr. X was the one who injected the patient. It is Dr. X who we will now prosecute. And it is Dr. X who will go to jail. And maybe there'll be a hefty fine too. And so justice is done. They've gone to jail. The patient is has got their compensation. We can wash our hands of it. It's finished. But then what happens if the same mistake happens a week later, or 1 month later, or 2 months later? Perhaps in the same institution or a different one in the country. Are we going to do the same thing? Are we going to prosecute another doctor? Are we going to put that doctor forward for criminal prosecution? Are we going to compensate the next victim? And so on and so forth. Now, the issue with this form of accountability is that while we might get justice, or perhaps it's justice for the patient involved in that situation, there may be bigger systemic problems that need to be fixed, and we're not addressing those problems. And the law has a big role to play in how we address problems in the medical system. The system I've described is what you call a blame culture. I'm not saying that Qatar has a blame culture, but the system I described is one, and it is a common problem in medical systems throughout the world. And so the problem with a blame culture is that you are essentially blaming a clinician who's trying to do their best, even though mistakes happen all the time. And in that type of system, what the most likely outcome when a mistake happens is that a doctor will not feel confident to speak up because they're fearing blame, they're fearing prosecution. And so that leads to two problems. It leads to, number one, what I was talking about before, which is we avoid the bigger issues that might be going on, the systemic problems that might exist in a medical system. And those are the true cause of the avoidable harm, the systemic problems. And second, it can lead to defensive behaviors. So it is not uncommon in other systems for clinicians to perhaps circle the wagon. They want to protect their own. If an accusation is made, they keep quiet. And so no lessons are learned. What if a patient has died and you have a grieving family and they don't get closure about what happened? All of these are matters which I think are best to avoid. These are situations we want to avoid, this blame culture. Instead, what there's a move towards and a greater recognition of, or a greater recognition of the need for, is what we call a just or learning culture. This is the opposite of a blame culture. This involves a proper study of what went wrong in the environment that led to the mistakes, and we learn lessons from those mistakes. So in this type of environment, the role of the law is to encourage staff to speak up, to feel confident that when a mistake happens, they can talk about it without fearing blame. And by supporting them to be open about their mistakes and learning about errors, we can prevent the same issue happening in the future. So there is still accountability for the patient now, but there is also accountability for future patients because we're identifying systemic problems that we're seeking to fix. And so the big question is does criminal law feed into this blame culture? And would a move away from a criminal law system to a civil law type of system encourage a just or learning culture? Now, I've used a couple of terms, criminal and civil law, which I'll come to in a moment. But first, I think it's worth noting that these issues have been discussed in Qatar before. I presented at the Qatar Patient Safety Forum a couple of years ago, and these were issues specifically addressed in keynote presentations where speakers referred to other countries like the UK grappling with this issue. So this is the broader context I want you to think about. What is the purpose of the law when it comes to medical liability, and what is it doing? This can help frame our understanding of the law as we read it and we consider it and look at it. So when we consider criminalization, what this essentially means, the difference between criminal and civil law, for those that don't know, criminal law is where a person is prosecuted and the sanction may be prison or a significant fine. It's often brought by the state, criminal law prosecution, not always, but it often is. Civil law, on the other hand, is a private claim against two individual parties in a civil court. And the sanction is not prison, it's usually compensation, it's usually a fine. And in the medical context, the compensation is usually covered by insurers. So that's the key distinction. But what we find in the first instance in the law in Qatar is the criminal law applying. So, and it's incentivized to in certain ways. So if you seek a judgment in the criminal court, the outcome of that judgment in the criminal court can be used as conclusive evidence for liability in a civil claim. So there's sort of an incentivization where you can to prosecute someone in a criminal court, I would argue, to then, prior to filing any civil claim, because that means then your civil claim wins automatically because you've got your conclusive evidence from a criminal claim. But I don't want to go too much into that because that is something I think Muhammad will cover in more detail in his presentation. But the starting point for the law where a mistake happens, it seems to me, is the penal code. So under Article 312, a person who accidentally harms another due to negligence can be liable up to 6 months in prison and or a 1,000 rial fine. There is an increase on that sanction where the harm leads to some deformity, and there's a doubling of that sanction where it is a result, the harm is a result or happens in the course of an offender's profession. So that would cover doctors conceivably. A doctor who is negligent and harms a patient would be liable in criminal law in the first instance to these sanctions. And so, again, I don't have conclusive answers to these. I'm trying to bring up a broader discussion here. Does the penal code have an effect on practice? I don't know, perhaps it does, but this is something that we need to look into. I want to focus on a specific term there in the penal code. You'll see under Article 312 is the term negligence. That's my terrible attempts at highlighting. So negligence is the term that we typically find in medical law for finding doctors liable. We need to determine that a doctor is negligent. So to determine it, there is a law, another law in Qatar called Law Number 2 of 1983. I call it the Practice of Medicine Law for short. And under Article 18 of this law, it states that a doctor is not liable where they show due care and where they behave in a reasonable and professionally orthodox or evidence-based manner. And this applies to diagnosis or management of the patient. So in the first instance, you're not negligent where you show due care and you act reasonably and professionally, in a reasonable and professionally orthodox or evidence-based manner. The law puts a bit more meat on the bones in determining what due care actually means. So a doctor is not acting with due care if the error that they cause is the result of ignorance of technical or basic scientific matters that every doctor should be familiar with. And if the cause of the harm to the patient was through negligence. So it's interesting looking at the law because point B there essentially restates the law on the previous page here in Article 18. But what point A states here is it gives a little bit more meat to the bones. It says where a doctor causes an error, and that error is a result of ignorance of technical or basic scientific matters that every doctor should be familiar with, then we can say the doctor has not acted with due care. Now, to add a little bit more meat to the bones, there is some case law which can help us to break this down further and determine how we prove this. So in 2018, there was the Court of Cassation case 84/2008. The Court of Cassation is the highest court in Qatar. And in that case, the court said, there are 3 elements that you must prove to find a clinician negligent. There are 3 elements. The first is fault, the second is called causation, and the third is called damage. You must prove all 3 to find a doctor liable for negligence. And it's a test, it's a tick box. So as a lawyer, you would go through each test and you would tick it off as you prove it with evidence. So beginning with the first one, fault. So in another case, case 3 of 2009, the court held that to determine whether a doctor is at fault, it must be determined whether the doctor had regard to the average knowledge and expertise of doctors acting in the same circumstances, the traditions of the profession, established principles, and basic scientific rules of the medical art. So typically this is proven through an expert report. So an expert report is considered by the court, by an expert committee, and the expert committee hands their report to the court, who then will assess the report. Now, I've highlighted the word art there for a specific reason. There is a famous English case called Bolam. And in Bolam, they essentially use the same terminology that you found the court applied there in 2009. So it seems to me that what is, to a degree at least, driving the principles of law in Qatar is English principles of English law, because the terminology is quite similar. And what does this mean in practice then? What does this test mean in practice? It means that if you can find a few professionals as a clinician, if you can find a few professionals who say what you did was in accordance with what another doctor would do in the same circumstances, the traditions of the profession, that you acted in accordance with established principles, basic scientific rules, then you acted with due care. And if you acted with due care, then you weren't negligent. Now, to prove if we go down the other path, if we had to say that a doctor is negligent, the court has quite a high threshold to prove. The court, well, not the court, the counsel. Counsel must prove that or the lawyers must prove that the clinician undoubtedly violated the principles that were stated in that case. So on the other hand, you might find other experts who say, well, there was a violation here. This is not normally how other doctors would act in these scenarios. Normally another doctor wouldn't have injected this medication in this location of the body. And it is clear that that is medical practice and the doctor deviated from that. The term undoubtedly shows that it's a very high threshold. You must be essentially so sure that the doctor violated those principles that they were negligent. So that's the first element. Let's go with it. Let's say that there has been a case that's gone to the court and the doctor has violated those established principles and we tick the fault box. Okay, we say that we think you did not act with due care for those reasons. So the next box to tick is what's called causation. The doctor must have caused the harm itself. So a typical test to ask is, but for the doctor injecting the medication, the patient would not have died. So if it was not for the doctor injecting the medication, the wrong medication, the patient would not have died. That is a simple way of explaining to you the but-for test. And in some cases, it can be easy to establish. It's clear. The doctor injected the wrong medication, the patient died, the doctor caused the harm. But there can be more complicated cases. And it was interesting to me to see that in case law in Qatar, they consider what are called loss of chance cases. So let's say that a doctor misdiagnoses a patient. So you go to the doctor, you describe your symptoms, and the doctor misdiagnoses your symptoms. Let's say the doctor says, okay, I think you've got an infection, I'm going to give you antibiotics. But in reality, the patient has something much more serious, which is cancer. Now, these are called, and then because the doctor misdiagnoses, the patient eventually dies. Now, there are different ways that the law deals with this, and these are called loss of chance cases. So there are different ways in which the law deals with loss of chance cases. So, for example, in the UK, if the doctor misdiagnoses you, and at the time of misdiagnosis, it's later found that you had, say, a 49% chance of survival if the doctor had diagnosed you correctly, then the doctor is not liable. There is no liability. On the other hand, if at the time of the misdiagnosis, you had a 51% chance of survival, the doctor is liable. That's the rule that's applied in the UK, but different rules are applied in different jurisdictions. In America, it depends on the states. So in the United States, there are different ways of allocating liability in these loss of chance cases. It may be that you can get compensation for a 20% and 30% and so on and so forth. But the loss of chance cases have arisen in Qatar, but I'm not sure, and it's not clear to me what rules are being applied specifically. Maybe Mohammed can speak to this, I'm not sure. But let's take the simple case anyway. Let's keep with this the simple thread of reasoning, which is that we say that the doctor injected the wrong medication. It's clear. We can now tick the causation box. That's 2 boxes. The third box is simply that some harm must have occurred. So maybe a doctor fell below the standards of due care, but in the end, there wasn't actually any harm to the patient. There must be some harm in the end. If there isn't harm, then there's no liability. So as long as there's harm, you can tick that final box, and it should be relatively straightforward to tick that box. So those are the 3 elements. If you can prove those 3 elements, you can establish under the law that a doctor was negligent. Okay, and that's going back to the term negligence and proving that somebody was negligent. In terms of compensation, this is covered under the civil code in Qatar. So compensation is generally limited to the loss incurred and profit forfeited by the victim. And there are also damages under the civil code available for mental harms suffered as a result of the wrongdoing, and even potentially to family members in certain circumstances. But again, maybe Mohammed can speak more to those if he so wishes. A final point I want to make on the negligence point is employer liability. And obviously this is a big issue in the medical context because a doctor is most likely employed by a hospital or a clinic. And so what typically happens is that an employer will be held liable for the wrongdoing of the doctor also. The doctor will still have sanctions, but the ultimate payment may be made by the hospital or the insurer ultimately. But we call this vicarious liability, the liability of your employer. The employer is the one who is in charge of you. You acted in the course of business under their employment, and therefore there is liability potentially attributed there to the employer also. And this is covered under Article 209 of the Civil Code. This holds an employer liable for the conduct of their employees acting in the scope of their employment, as I mentioned. So let's take a step back again. And the question is what sort of medical liability system do we want? Do we want, just to take a step back, the starting point to be about this, criminal law? Is the starting point the penal code? Is the starting point that if you are negligent, you are subject to criminal prosecution? Does that have an effect on doctors speaking up openly and frankly about what went wrong? I don't know. It may or may not, but I'm asking questions. Do we instead perhaps want to start with the negligence standard as the default standard? So we start by deciding whether there was fault, causation, and damage, and the sanction, rather than being prison, is perhaps compensation and other sanctions that are necessary in the circumstance. And perhaps in questions and answers, we can talk about the other sanctions that are available through the ministry, such as blacklisting of doctors or revocation of licenses. There are other ways that you can sanction doctors than merely prison. Is prison really the ultimate sanction that should be appropriate in every case, or a hefty fine? Or is this the better starting point? Is the better starting point to start with the negligence standard and say, okay, if somebody is liable, then there is potentially compensation and other sanctions? Would this type of system encourage people to speak up more? Now, this is the default system that you have in the UK, for example. Again, I'm not saying that this is the system that we should have, but I think it's important to have this conversation and for more research to be done on this. And I'm not saying that criminal law should never apply. There are certainly circumstances where criminal law should apply. And I want to briefly and finally touch on three matters in the last 5 minutes here of my presentation, where the criminal law has applied, and I would argue for an important reason. So if we consider infectious diseases and the COVID-19 pandemic, the main law in the country is the law number 17 of 1990 on the prevention of infectious diseases, which was amended this year. And that amendment led to the creation of a health prosecution. And the law itself creates a wide burden on doctors and those in society who have some formal relationship with an infected person to report that. So that could be doctors, guardians, the university, direct managers, employers, school representatives, and more to report if somebody has an infectious disease. And there are lots of provisions in that law. And that law comes with very strict punishments, which can be up to 3 years in prison and a fine up to 200,000 riyals. And it may be in these circumstances, we carve out areas of liability for doctors who don't report an infectious disease for a good reason, because there is a dangerous disease that's spreading and it may harm society more broadly. And so there may be a concrete reason for having those sanctions in place in those circumstances. The same in organ transplantation. The law number 15 of 2015 criminalized the trade of organs. There is a problem in a number of countries where people purchase organs. And that is abhorrent for many reasons, which we will not go into here, but there are clear, well-researched reasons why you shouldn't have an organ trade. And the law in Qatar has very strict sanctions, the new law, where there is a trade of organs. A person can be imprisoned up to 10 years in prison, and there can be a 1 million riyal fine. And the purpose is not only to avoid having an organ trade, the purpose is also to encourage people to have organ transplantations here in Qatar under their system, which is actually quite good and advanced now. So 10 years ago in 2009, 95% of patients in Qatar traveled abroad for an organ transplantation. But by last year, the number had dropped by 85% because people are having them here. So you see another example there of the criminal law serving a positive purpose. And finally, mental health law. There is a stigma of mental health in the country, and it's a big issue. And what the law of number 16 of 2016 has done is to protect patients from all sorts of situations. Perhaps there's a doctor revealing information that shouldn't be revealed, breaching confidentiality. There are strict prohibitions for that, and which involves imprisonment and fine. So you can see in these circumstances that there are situations in which the law, we can carve out certain exceptions in the criminal law, which might be sensible. But the question is, should they apply? Should we have criminal sanctions for general medical liability? And what effect does that have? That's the bigger question that I think needs to be discussed. And I will, and it feeds into that broader issue about whether we want a blame culture or a just culture that's happening in the country. So as I can see, I'm on 29 minutes and 32 seconds. So I'm just under my 30 minutes allocation, and I shall stop now and hand back to Susan. So thank you.
Thank you so much, Dr. Solaiman, for that presentation and teeing it up in terms of allocation of the legal system in terms of particularly the criminal and negligence. There are a couple of questions that have come in, and just to we can think about them as we go forward. I thought perhaps you did answer one of them, Dr. Solaiman, and that is who decides on whether there is a breach of the duty of care. And you gave us insight into the expert report and the like. Another interesting question was just examples of instances in which we see negligence. Are there certain concentrated areas in the country? We can deal with those later. I thought what was very interesting, though, was this issue of what can we learn? And if we take a learning approach, what does it mean in terms of education within hospitals, within medical practices, and the value associated with that, and then the role in which insurance companies can come into play and perhaps help shape that to minimize any risk that would be associated with any type of negligence and the like. So thank you so much. Mr. Hashim, please, the floor is yours.
Thank you very much, Dr. Susan. I would like, first of all, to thank the College of Law and Public Policy of Hamad Bin Khalifa University and Sulaiti Law Firm for making this presentation possible. I'm really honored to be with you, Dr. Susan and Dr. Barry. And without any further ado, let me share with you the presentation, and let's start. And just want to confirm if you can hear me clearly.
I can hear you.
Okay, great. Now, so we're going to start with the legal procedures in medical misconduct cases, which occurs in several instances, as Dr. Barry stated. The instances are numerous, actually, and there isn't a very specific part that we see prevailing, although we would say that sometimes it involves surgeries and so on. This is the most part where damages are severe and needs to be addressed in a legal way. This what sometimes prevail, but usually any misconduct can be brought before the courts. So today we're going to discuss four main matters. That is the preparatory phase. How do we prepare for a misconduct case? How is the criminal action brought, the civil action, and the medical complaint? So starting with the most important phase, which is the preparatory phase, and I do call it as very important because when you prepare correctly for a case, you will know that you're going in the right direction. Because if you prepare the case correctly, you avoid a lot of obstacles that you may face. So in doing that, the victim or the injured needs to prepare some matters like the facts and details of the injury, and to prepare them chronologically. This is very important because as much as the facts and details are clear and arranged, this will ease things for the court, given that the situation is medical and it's kind of complicated before the court. In addition, there are some evidence that needs to be submitted, like the medical reports proving the injury itself, maybe the medical reports before the injury to prove how the case proceeded, and the effects of the injury as well. And also for the claim of compensation, you may prepare the costs that you have sustained because of the injury. So as a quick example of that, if an employee gets terminated for health reasons because of the injury that he sustained, then this is a financial damage, and this can be one of the items of compensation that can be claimed. On the other hand, we do recommend that victims or injured needs to meet with legal professionals to help them assess the case itself and assess the whether there is a medical misconduct in that. And I would speak about that in our law firm and in our experience, because we do that on regular basis. So what we do is we assess the facts and details with the client, and we believe that assessing these facts and details is very important, because sometimes victims may think that there is a medical misconduct. But then when we study the facts with them and we study the law, and in most of the cases, we meet with medical professionals in order to ask them what is prevailing in the medicine practice. Is this really a medical mistake? Of course, this depends on each case, and it differs from one case to the other. But in all cases, we feel that we need to meet with medical professionals. As lawyers, we do that, and this what maybe sets our law firm apart from others, is that we take due care of the case even before we start it, even before we go to the court and say, let's file a complaint or let's file a case and so on. We need to study it very well. Sometimes we give a legal opinion to our client before even starting anything, in order for the client to have clarity of the situation and to be in the safe side as well, because we don't want the client to be facing obstacles during the case. In addition, when we're done with studying the facts and assessment of evidence and so on, we move to the next step, which is setting the strategy of the lawsuit. So we may take the criminal action and the compensation in addition to the medical complaint. We can take them all together, or we can take one of them as the case may be, and depending on the request of the client. But usually we take all the measures all together at the same time. After that, we're going to move to the speaking about the criminal action. First of all, is it a must? Do you have to lodge a criminal complaint or proceed with a criminal action every time there's a medical misconduct? Is this really required for the proof of the civil liability in order to claim for compensation? Well, it's not a must. You can proceed with a legal civil claim for compensation without asking or without lodging a criminal complaint. But the criminal court's judgments are conclusive evidence for liability in civil claims. So if you have a judgment from the criminal court proving the medical misconduct, when you file your civil claim, to claim compensation, you don't have to prove the medical misconduct itself, because it has already been proven in the criminal court and so on. So you don't have to proceed with that anymore in the civil case. But in the civil case, you need to prove the damages that occurred and so on. Then, okay, now how do we proceed with the criminal action? Well, it happens by lodging a complaint to the public prosecution. And in doing that, you need to submit an illustrative memorandum with the evidence attached to it. And it should be noted that the medical reports prepared by governmental entities have a stronger evidence, or forms a stronger evidence before the public prosecution. The public prosecution may not look into the medical reports submitted by private institutions, but in any case, also all reports and documents submitted to the public prosecution has to be in Arabic. And in doing that, after lodging the complaint, what happens? Now, the investigation starts, and the public prosecution may, in its opinion, because it's a medical complicated matter, may ask the appointment of a medical expert, or could be a committee of medical experts, in order to examine the medical situation of the injured, in order to examine the medical evidence and provide a report to the public prosecution. And this usually occurs when the public prosecution does not have a medical report from a governmental entity, but it's again, it may happen at the discretion of the public prosecution. When the investigation is done, the public prosecution may refer the case to the criminal court and notify the accused person if they see that there is a criminal act. When the case goes to the criminal court, you need to, or the victim needs to, prove the medical misconduct or prove the situation before the court. And again, this happens by submitting all the medical reports and the documents related to that. But we are faced sometimes by some instances where the victim or the injured is not able to provide so much evidence or documents because they are in the entity against which a litigation is brought. So there might be some difficulties or obstacles before the injured. And in these types of cases, what we do is that we submit a request to the court to compel the medical entity to submit the documents that it has in the medical file. Also, this happens not only for the entities themselves, but even if it's a medical practitioner and so on, this applies to them as well. Afterwards, the victim needs to prepare or submit the expenses and costs that he sustained because of that injury, as we spoke. And again, because the language of the state of Qatar is Arabic, any document submitted to the court has to be in Arabic. Now, finally, beside all of these, the court may, in its discretion, and this is usually the case, appoint a medical expert or maybe a committee of experts, again, to examine the injured, if this is possible, because in some cases, there is no use of examining the injured himself, but there is a use of the medical expert to examine the medical evidence and documents submitted to the court. Now, what does the expert do exactly, the medical expert? How does he proceed with his mission? So actually, the medical expert has to meet with the litigants, both the victim and the accused, in order to listen to their statements, their point of views about the situation, about the medical misconduct, and then he studies everything and submit a report to the court of his findings about the entire situation. Now, there are some cases where the victim or the accused do not like or do not agree with the medical or the report submitted by the expert. So in these types of cases, the medical the victim and the accused may either reply to the report of the medical expert, comment to it, or even challenge the appointment of the medical expert himself. So in some cases, there are conflict of interest or maybe negligence from the medical expert in carrying out his mission. So in these cases, the victim or the accused may ask the court to change the medical expert or the committee of medical experts. Now, we come to an important point about the claim of compensation before the criminal court. Now, as we know, the compensation is a civil claim, and it has to be brought before the civil court. But exceptionally, the civil action and the claim for compensation can be brought before the criminal court. And this is an exceptional procedure granted by the criminal procedure law here in Qatar. And when we speak about claiming compensation, generally either before the civil court or before the criminal court, the court actually uses its discretionary power to determine the amount of compensation, but it does so in light of the physical and psychological damages that the injured sustained. And this again brings in mind that if damages are clear and proven in front of the court by clear evidence, as we discussed, this will support the court and support to give a clearer evaluation of the amount of compensation, because damages in this field may range from like the physical damage that happened, exactly, the costs sustained to cure this physical damage, as the example that I've mentioned earlier. If the person loses his job to that, or gets shifted from one position to another with a lower salary, all these things are damages, financial damages that can be proven, that can be submitted to the court, and according to that, and in light of that, the court will evaluate the damages that occurred and gives the amount of compensation. Now, as we stated, that initiating the criminal action before the civil court is an exceptional procedure. It can occur only in front of the court of first instance in the criminal phase. So if you miss that out, you cannot bring it or initiate it before the criminal court of appeal, but instead a separate civil lawsuit for compensation can be brought before the civil court. I want to move to an important part as well of the criminal action, which is the Islamic Sharia provisions. A lot of people may ask when the Islamic Sharia provision applies and to whom exactly. Well, the simple answer comes in the law that the Islamic Sharia provisions and penalties applies to the whenever the accused or the victim are Muslim, and in certain crimes that are stated in the law. Some of them are blood money or diya crimes, or qasas as we call it in Arabic, and these are crimes that leads to death or injury. The Islamic penalties in these cases are diya in case of death, and also arsh in case of injury. So diya is the amount that is gained in expense of another person's life. So if the victim dies because of the medical misconduct, at the victim's choice, or in this case at the heir's choice, they may choose to apply the Islamic penalty if they or the accused are Muslims, as we said. And diya in this case is 200,000 Qatari riyal. And in addition to this penalty, there's an imprisonment for a maximum period of 1 year according to the penal code. Then there is another sort of Islamic penalty, which is the arsh, and this is an amount of money that is given in proportion to the injury that occurred to the person. And this comes also in addition to an imprisonment for a maximum of 2 months in cases of medical conduct that leads to injury, not death. Now, the question that may come into mind, now I'm getting an amount in addition to a criminal penalty, which is imprisonment. The question is diya, or the blood money, and arsh are compensation? Well, this question is answered by the Qatar Court of Cassation, as well as the Civil Code in Qatar, where both agreed that arsh and diya are not compensation. Simply, arsh and diya are Islamic penalties, not compensation. Although they are financial penalties, they are not compensation. And this means that claiming compensation can be made in addition to the Islamic financial penalties, whether it is arsh or diya, or the blood money as it's called. Now we move to the criminal judgments and how they are challenged. Well, after the court decide on the situation by giving a judgment, the court will also decide on the compensation if the civil action is brought before the criminal court, as we decided. And in this case, the convict may choose to appeal the judgment within 15 days from the date of the judgment after trial. Now, can the victim also challenge the judgment? Well, yes, this is possible for the victim. Actually, in these cases, the public prosecution may challenge the judgment on its own without even having to receive a request from the victim himself. And the public prosecution can do that within 30 days from the date of the judgment. But just in case the public prosecution is not proceeding with the appeal, we always submit a request to the public prosecution with the reasons of the appeal, explaining why would the public prosecution, why does the public prosecution have to appeal the judgment. So this takes us to the next step, which is the case before the Criminal Court of Appeal, which is a sort of a retrial that enables both parties to submit their argumentation. And when the Court of Appeal issues its judgment, there is a chance for both the convict and the victim to challenge the judgment issued by the Court of Appeal in front of or before the Court of Cassation, which is the highest court in Qatar. And the challenge can be made within 60 days from the date of the judgment. And it's really important to understand that before the Court of Cassation, you can only bring legal argumentation related to the application of the law itself. So any matters related to facts cannot be brought to the Court of Cassation, otherwise they will be rejected. So I want to move quickly to the civil action. As we said, the civil action to claim for compensation can be initiated before the criminal court, as we explained, or in a civil separate lawsuit before the civil court. But if you initiate it in front of the civil court, you need to provide all the evidence and to prove the medical misconduct before the civil court. And in this case, all the matters related to proof, evidence, medical experts, their reports, compensation evaluation, the challenge before the Court of Cassation, all these matters are similar to what I have explained earlier in the criminal action. So I don't want to be repeating myself. They are similar, but the only difference may lie in the period to appeal the judgment issued by the court of first instance or the civil court of first instance. The period of appeal is 30 days from the date of the judgment. So both the victim and the medical practitioner can appeal judgments of the civil court within 30 days. Now, we want to go through the medical complaint, how to proceed with the medical complaint, and what is the aim of the medical complaint. Well, the medical complaint can be submitted to the fitness to practice section, which is a section under the Department of Health Care Professionals that are both under the Ministry of Public Health. Before 2019, when the amendment came to the law and reformed the departments of the Ministry of Public Health, the complaint used to be submitted through an online system. Now, currently, we do submit them by hand, and we follow them up periodically. And I think in a very short period of time, it will be available again to be submitted online. But what is the aim of the medical complaint? Well, the aim of the medical complaint is the application of disciplinary measure against healthcare practitioners. This is not a criminal penalty. And again, the medical complaint and the disciplinary penalties or measures that can be taken against healthcare practitioners can be applied in addition to the criminal penalties. So generally, what we're looking at in cases of medical misconduct is the application of disciplinary measures, penalties of criminal nature, whether of Islamic nature or according to the criminal law, and also the compensation, which is the damages, the compensation for the damages that the victim has sustained. Now, back to the medical complaint. What do you expect from a medical complaint? What happens? Well, there are some disciplinary sanctions that may apply depending on the seriousness of the misconduct. And this is evaluated by the competent section of the Ministry of Public Health. So it may range between a warning to the medical practitioner to maybe a suspension of the practicing the medical profession for a period not exceeding 1 year, or maybe the withdrawal of the medical license from the doctor and removing his name from the schedule of doctors, sometimes also blacklisting the doctor. So I want to conclude that the medical misconduct is a very serious matter that needs to be correctly addressed. Again, preparation is almost 50% of having a successful claim before the court. Studying the case and explaining it in the most and the easiest manner and the simplest manner to the court will ease things up and will make the court understand the situation in a very correct way. And in doing that, I want to give an example that we've done in some of the cases, that we try to project or give a presentation to the judge using technology, using like presentations, PowerPoint presentations and screens. Like we try to do that in the court. And this actually have a very good and positive reaction from the court and from the judge, because when you read a document and understand it is not as when you are physically before the judge explaining with some maybe charts or a PowerPoint presentation. This gives a clearer view to the judge, and it needs some permissions to be done and so on. And as law practitioners, we can proceed with that. So once again, thank you very much. This concludes my presentation, and I'll be very happy to receive the questions. Thank you.
Great. Thank you so much, Mohammed, for that presentation as well, which covered a lot, particularly in the area of the criminal proceedings and also the important issue of the medical complaint. And you touched on the expert report, and this gets back, I think, to the initial question that we received, and that is who decides whether the doctor or any medical practitioner engaged in at the standard of care, reasonable standard of care. In the United States, for example, that would typically be done by a jury. However, there are experts. And the other thing Mohammed just referred us to was the fact that we have this medical complaint procedure and the extent to which any evidence in that medical complaint procedure could be relevant. And then once we get through this issue of who decides and the role of the expert report, a follow-on question dealing with the expert report, and then we're going to get into some discovery-related issues, but is and Mohammed, you touched on this a little bit as well, is the level of expertise in the country. Do we have sufficient capacity? Are there concerns about people being related to each other professionally? Are there attempts to try to bring in experts from outside of the country and the like? Because you talked about, Mohammed, about being able to challenge an expert and the like. So let's start with these 2 or 3 questions, and then we'll then go into some little more detail as to what happens in terms of an internal investigation, perhaps that could occur, a discovery of evidence related to that and the like. So I defer to either of you to kick it off.
Would you like me to just give some
Sure.
context, and then
Sure.
Mohammed, you can give the specifics?
Sure, please.
So just to give some context, I've looked into all of the publicly available Court of Cassation cases on medical liability, and every single case, except for one, which goes back to what Mohammed was saying, which is that they will usually have an expert report. Every case except for one mentions expert reports. So I think that the significance of them is quite high. So for example, in one case, in 2009, it was held that a lower court had erred in not appointing an expert committee to determine the mental health of the appellant, even where a request was made. In the case of 2008, it was held that a lower court had erred in applying the law because it relied upon an expert report that was nullified. So there are cases, I think the case law shows, I think that's just a little bit of context perhaps, and then Mohammed, you could speak to the specifics of the procedures.
Thank you. Yes, I first of all, I do agree with Dr. Barry, and I would stress the fact that the experts before the court plays a very, very important role, especially in matters of very complicated matters like medical misconduct. It's really a very complicated matter. No one could easily understand it. No one has the experience to understand it. It's not as engineering, for example, because in engineering, you kind of may, look at a building and tell, yeah, there's some dangers or not, just from a general point of view. And this is not always the case, but in medical misconduct, it's really that hard to understand without a medical expert. And that's why the court or the public prosecution may ask a medical expert to be present in order to study the case and maybe study the evidence submitted or examine the injured person himself. And this is very important because this contributes in illustrating and simplifying the matter for the public prosecution or for the court in order to be able to give the correct judgment. In doing their work, there might be some complications, we as lawyers, generally speaking, not in cases of medical misconduct only, but we face sometimes some difficulties with some experts where, for example, an expert refuses to carry out one of the missions, or maybe is carrying it in a wrong way or something like that. And in these cases, you can simply report to the court with the matters that are happening and the negative sides that you have seen with the expert. We have done that in several cases. We have submitted complaints to the competent department responsible for handling the works of experts, and also to the court. And we have very positive reaction from the court. The court says, okay, now we have a litigation between one of the litigants and the expert. So we're going to set aside this expert and appoint a new one, or change and so on. Sorry. And this is one of the things that happens frequently, actually. But this does not mean that like we are experiencing trouble with all the experts and so on. Not everyone is perfect, not everyone is always mistaken. So there is always the possibility to complain against the medical expert. And even sometimes, even if the medical expert submitted his report to the court, and one of the victims, the victim or the accused, would like to change the expert, this can be done through commenting to the to the report submitted to the courts, because sometimes reports are not clear to a manner that the court may refer the case back to the expert in order to clarify some matters, or maybe, depending on the situation and the seriousness of the mistakes of the expert, the court may refer the case to another expert, or maybe a committee of experts. Now, on the matter of using international experts, or experts that are not from Qatar, this can be possible, but in a very limited situations where there are no expertise in Qatar. So usually the court refers to governmental entities to ask for practitioners or medical experts. But if there's a really specific like field of expertise that is not in Qatar, which I doubt, then the use of international medical experts can be possible.
Great.
Can I just ask a very quick question, Mohammed?
Sure.
Let's say that the court is satisfied that there are no problems with an expert report. Do the courts in Qatar basically accept the findings of the expert report? Do they ever challenge them or disagree with them, or do they say, no, these are the experts, these are the people who know this very complex field, like you mentioned, and they apply that report?
Yeah. Well, the court assess the expert's report. Of course, the court does not have the medical experience to go into technical or very medical nature detailed matters, but the court, as we say in the law, the court is the highest expert. So sometimes the court sees that the expert is not compatible with the facts, or it's simply like is not correct. So in most of the cases, the court would say, okay, this is a correct one, but in some other cases, the court would say, I don't agree either partially or totally with the report, and according to that, it may either appoint another expert on its own. It doesn't have to come from the victim or the accused, or it may just refer it to the same expert again for clarifications and further detailed comments.
Great. A question that came up fairly early dealt with internal investigations, and that is there could be peer review reports, analysis done internally in a hospital, ways in which perhaps they're trying to improve themselves, and the like. How do these type of documents come into play in litigation? Are they are there means by which this evidence could come in at trial that, or in the United States we would be, we would say it would be discoverable and the like?
Well, these types of documents, whenever I assume that these types of documents, if they will not be submitted by the accused, who is the medical practitioner himself, it would be hard for the victim to acquire them or ask for them, because usually they are internal documents. But if the victim is aware of such thing, we can ask the court to ask or compel, actually, to force the medical entity to submit these types of documents in order for the court to have a clear view. So usually what we can do is asking the court to do that, and in like almost 99% of the cases, the court accepts and issues a preliminary judgment or a judicial order to the medical practitioner or the medical entity to submit such types of documents.
Great. Can I ask a follow-on question? And maybe this is probably for both of you, but let's assume that there is a hospital that wants to before it opens its doors, it has the gold standard in terms of training, in terms of policies, and the like. And it goes through this extensive process to set up a system of notification of if there's something wrong, peer reviews, and everything. Does the system in Qatar generally is it encouraging that, or is the legal system such that fact going to potentially hurt somebody? I mean, not hurt somebody, but a doctor if they're being investigated.
I think an important point to bear in mind is that all of the major hospitals in Qatar subscribe to international accreditation standards, and they're extremely strict standards. And patients, if they wanted, could complain to the accreditation body that oversees the hospital, and those are the gold standards from the very best countries in the world. Whether it's in the accreditations in Qatar generally arise from the US, Australia, Canada, and in some cases the UK. So I suppose that's a context for it, but perhaps Mohammed can speak to situations where there isn't an accreditation body that a clinic has subscribed to, for example, because not every liability issue is going to arise from a hospital.
Yes. This falls under the medical complaint that I've addressed in my presentation. So actually, you don't have to complain to a certain medical entity. You can complain against any practitioner. And as you know, each practitioner here in Qatar, each medical practitioner has a license number that has to appear on the prescriptions and stamps that the doctor uses and so on. And to ease things up for victims, these information are accessible through the website of the Ministry of Public Health. So if you lack some information about a certain medical practitioner, you can look him up or look her up at the website of the Ministry of Public Health, get more information about him, and this helps a lot with the procedures and with the complaint itself.
Great. That is a perfect introduction to another question that came in, and to the person who asked the question about the types of cases, we're going to get to that. But a question that came in dealt with the issue of is there an international registry of doctors, so that let's assume we have a doctor that has received a sanction in another jurisdiction. Is that information available, for example, to a hospital here in Qatar? And furthermore, is it available to prospective patients as well? I know in the United States, at least in my jurisdiction, for licensing of lawyers, all that information is on our State Bar webpage if there are issues and the like. But the question was, if there is a complaint, is there, and it's been established and it results in some type of a penalty, is that information then something that goes with the person regardless of the jurisdiction?
Okay, well, the international accreditation is simply a registration of the medical entity in that international entity itself. So if there are some penalties issued from Qatar, those penalties can be communicated to that accreditation party, and it will depend on each jurisdiction. So maybe in some jurisdictions, they will apply certain sanctions. Maybe they will suspend, for example, their accreditation, or maybe cancel the accreditation. It actually depends on the jurisdiction. But we can say that in order to have the penalty or the judgment issued proving the medical misconduct approved internationally, there are some few steps to be taken, which are to have the judgment signed by the competent signatory in the court, and then take it to the Ministry of Foreign Affairs to have it attested, and then maybe from the embassy of the country to which this judgment is going to be sent, in order to have the international aspect, or to cover the international aspect for the document to be accepted before other jurisdictions. So yeah.
Great. Barry, do you have any thoughts on that? I think it's a great question because it deals with regulation across borders, and perhaps the need to have a central clearinghouse around
I'm not sure
around
that
the
there's
world.
a central list that I know of. All I do know is that the QCHP, the licensing committee of the Ministry of Public Health, would obviously check into the records of any doctor that come in, but I really wouldn't know if there's a central list. That hasn't come to my attention anyway in my discussions with entities.
Yeah. Can I then follow up on one of the earlier questions that was asked, and that was, do we have a sense of the types of situations that are more likely to give rise to claims of negligence? The certain categories of cases, or are they just across the board?
Yeah, well, from our practice as a law firm, we have seen several medical misconducts and types and instances of arising or raising the medical misconduct. Usually it comes with surgeries in general. This is, let's say, could be the majority. But then we have the wrong prescription. We have a misdiagnosis, late diagnosis, or incorrect medical procedures, or maybe excessive medical procedures, like when the case does not, like somebody has a flu and you get him into a surgery, as an example. This is not compatible because the situation does not require a surgery, and so on. So these are the most types that we see in our law firm. Yeah.
Great, thank you. Another question deals with evidence, and that is in the United States we have the doctor-patient privilege. And this question is, could the doctor claim the privilege during discovery against the claimant to prevent them from getting access to certain documents and evidence? I have an answer for the United States, but I'm curious about what goes on in Qatar.
Yeah. Well, again, usually the client or the victim or the injured has the right to claim a copy of his medical file. Well, I have seen that practically in the Hamad Medical Corporation. where some of our clients requested a copy of his file and even was able to get a CD for the x-rays and things that he has done. Simply, this was made upon a request that was submitted to Hamad Medical Corporation, determining exactly what does he want. He was just ticking the box, I want this, I want that, submit the report, and I think within 2 to 3 days, he received everything that he wanted. And if the victim suspects that there are some missing documents, again, he can ask the court to compel the entity to submit these documents, or ask the expert himself to move to the entity and check these documents over there, where like to check them on ground. And maybe this will give him also a better view of the circumstances where the medical misconduct occurred.
Right. Yeah, in the United States, at least in some of the jurisdictions where I work, the privilege is the privilege of the patient. Mm-hmm. And once the patient asserts the claim, it's in effect a waiver of any privilege, and it can go both ways. You know, it can really cause some additional revelations on behalf of the patient, but also then getting a lot of information from the doctor. Dr. Berry, I don't know if you wanted to chime in on this subject. Okay, great. We have another question that deals with the Ministry of Public Health. And just to, I think it's point of clarification to confirm that when complaints are brought before the ministry, then those are not claims seeking monetary compensation, correct?
Yeah.
Yes.
So
yeah.
there are no
ahead,
compensatory powers within the Ministry of Public Health. There is the Fitness to Practice Department, which liaises with the Permanent Licensing Committee when they're doing investigations, but ultimately the sanctions don't involve financial compensation. They can be verbal or written warnings, the requirement for further education, a change in the scope of the practitioner's practice, suspending the registration of the practitioner or facility, revoking their license, and blacklisting them from working within the GCC. But there are no compensatory powers.
Oh,
which would necessitate, if you want compensation, to go down the legal track.
Right, and I'm glad you mentioned about the GCC, because that does get back to the previous question about and maybe I didn't phrase it exactly the way it was asked, but does the ministry communicate to other jurisdictions about disciplinary actions and the like? So that was very helpful. Is there the follow-up question dealing with the issue of the complaint was the question said compensation. If you want compensation, then you have to go to the Ministry of the Interior. I assume you see the question. I don't know if that's correct or not. You talked about compensation by way of the court system as opposed to the Ministry of the Interior, but I just would think about getting a response on that.
Yeah, well, usually the claim for compensation can be made, or usually it's made before the civil court. But again, it can be brought before the criminal court of first instance only. These are the two only ways where compensation can be claimed. So no other entity can give any sort of compensation.
Yeah. Great. Well, let's go back. I see there's another question that deals with the obligations of the head of the hospital. We'll get to that one as the final question. But let's get back to this other threshold question of the issues of the way we are going to structure our society. Do we see efforts to try to have more of a civil approach? Do we see any changes? I'm just trying to think of the future. Or do you think we're going to continue sort of with this bifurcated system, which really does have a strong focus on the penalty, which I learned today for the first time. I don't work in this area, about the significance of that criminal penalty in the civil context as well. I'm just sort of looking forward question.
Not from what I can tell. Maybe Mohammed's got a different experience, but from what I can tell, the laws that have been put into force and the laws that are in development, they still retain criminal sanctions within those laws. So I haven't seen a move away from that personally.
Yes, I do agree. Penalties do apply. And again, in addition to regular penalties, the Islamic penalties may apply in case the victim or the accused are Muslims and at the option of the victim. So the victim may choose to apply the Islamic penalties or not. So these two penalties do apply in addition to the request for compensation and the disciplinary sanctions as well.
Right. It's very
And
interesting. Go ahead, Barry.
You see, this is just the, I guess the concern is that if we continue down this path, are there systemic problems that aren't being solved? I really don't know. This would require research, and this would require surveys to speak with doctors anonymously to find out what is actually happening in the system. But if I may just briefly, there's for example, a body in the UK called the Healthcare Safety Investigation Branch. And what they're tasked with doing is, without apportioning blame or any liability, they have no powers. They select 30 cases every year of where there's been misconduct, and they investigate those cases, and they come out with a report which hospitals distributed to hospitals to implement, where they suspect there might be a systemic problem. So, for example, here, if I'm just going to share a screen quite quickly, this is one of their reports here, and you have, I'll just scroll down. There was the one case investigated, for example, involved these devices called flow meters, and had been an issue concerning liability that arose. So what the UK system is trying to do, and I think this would be nice to see replicated elsewhere, are reports like this, where they then report on what an incident was. This might be an incident that applies in many hospitals or clinics, and this is what to do to resolve the issue so that the same issue doesn't happen again. So that's just a quick example, but I don't know whether the system, having the criminal sanctions, would allow for that type of openness, or if there's a way of doing that within the system we need to think about.
Yeah, it's always the tension between acknowledging problems, and it could be in any context, trying to fix them, and then the consequences of that process for liability going forward. And this does play into the last question, and it was sort of a variation of a question I asked earlier, but that is vicarious liability for a hospital, and potentially even the head of the hospital. Are there things that can be done to perhaps minimize that, such as policies? Having policies in place, and if you have the policies in place, and if there wasn't an enforcement of the policy, that's one thing. But if there wasn't adherence to the policy through a specific doctor, then how does that relate in terms of the liability higher up the chain? And that will be the last question.
Would you like to go first, Mohammed, or?
You can go. You can go.
Well, as far as I'm aware, and perhaps I'm wrong, but as far as I can tell, the law is pretty straightforward in this regard, that there is employer's liability for harms caused by an employee in the scope of their employment. That's in Article 209 of the Civil Code. So I don't know whether there's a way of, I'm not sure that a hospital can avoid that responsibility. Perhaps there will still be liability for the doctor, but I think blame might be attributed to both. But that is my reading of it. I don't know, Hamad.
Yes, well, I do agree with you. You're absolutely right. We usually, when we file complaints or criminal cases and civil cases exactly, we have the medical entity itself, the employer, as one of the parties responsible for the compensation, not for the criminal sides and so on, but just for the compensation. So when we lodge or when we file the civil complaint or the civil action, we actually have the medical entity and the doctor as opponents to be jointly and severally liable for the civil rights, for the compensation, and so on. And it may also occur to engage some other people. So, for example, we have a case where some x-rays were not made correctly and led to the fact that the doctor did not diagnose correctly, and the doctor should have asked the x-ray department to repeat that x-ray in order to be clear and so on, but they didn't do it. So in this case, we have the doctor responsible for the x-ray and the doctor himself, the practitioner who misdiagnosed, and the hospital himself, all together in the lawsuit, jointly and severally liable for the civil rights, for the compensation. So yes, the entity itself is liable for the civil rights.
Well, on that note, I would like to first thank Mr. Mohammed Hashim and also my colleague, Dr. Barry Solomon. Again, I'd like to thank my counterparts and friends at Sulaiti Law Firm who have been so helpful in putting this together. This is a chance for us to really learn about what's going on in the country. And if anything, I thought that there are, particularly I see some of our students are participants in today's forum. This is a way for you to think about some research topics. I think some of these were clearly brought out, and how you can then start engaging in research, writing a paper in this area, perhaps be able to help shape policy and the law and through this analysis. And finally, if I could just say, over the summer, we're going to be having another webinar, this time with the Qatar International Court and Dispute Resolution Center on July 12th at 4 p.m. Doha time. And we're going to have Lord Thomas, the president of the court, and then we're going to have the chief judge out of the Northern District of Texas, Barbara Lynn, talk about trials in this COVID-19 environment. It's probably too early to say post-COVID-19, but we encourage everybody to participate. This medium is allowing us to engage an audience around the world. We would love to be in the same room together and afterwards have a cup of tea. We're not able to do that, but at least we can share each other's company. So again, thank you everyone for participating. Special thanks to our speakers. Thanks again to the audience for your great questions, and have a good day. Bye-bye.
Thank you, Dr.
Thank you for the
Susan.
questions.
Thank you.
You bet. Okay, thank you.
Thank you,
Thanks.
Dr. Susan and Dr. Barry and Mr. Mohammed. And of course, thank you to our attendees, and hopefully we'll tune in for the next webinar. Thank you.
Great. Shukran.
Thanks.
Thank you.
Thank you.
Yeah.
Goodbye.
Bye-bye.
Bye-bye.